Choose any ATM of your convenience and stand a chance to win gold sovereigns.
Lanka Pay.
In Parliament yesterday, Prime Minister Dinesh Gunawardena commented on the recent verdict delivered by the Supreme Court concerning the Inspector General of Police.
ශ්‍රේෂ්ඨාධිකරණය පොලිස්පතිතුමාගේ වැඩ තහනම් කිරීමේ අතුරු නියෝගයක් නිකුත් කළා තිබෙනවා.
The Supreme Court has issued an interim order preventing Deshabandhu Tennakon from serving as Sri Lanka's Inspector General of the Police. According to Article 42, Clause A2 of the Constitution, unless the Constitutional Council has approved such an acting position based on the President's recommendation, no individual can be appointed to the post of IGP for a period exceeding 14 days. Pursuant to the existing constitution, the President does not have the authority to appoint a person to the position of acting IGP. Therefore, the Supreme Court cannot expect the President to appoint an officer to the acting IGP position. According to the Police Ordinance, administrative powers of the police are vested in the IGP. There are no legal provisions preventing the IGP from performing his duties. Consequently, the President cannot appoint an acting IGP and simultaneously prevent the current IGP from performing his duties. The former IGP remains the IGP of the police and the position has not been vacated. The Constitutional Council operates as a legislative body in accordance with the Constitution. Thus, the decisions of the Council are considered to be constitutional decisions. The Constitutional Council is accountable only to Parliament, which is the supreme authority. A court cannot question the decisions of the Constitutional Council. Therefore, the Supreme Court does not have the authority to investigate or issue orders regarding the Council. As such, the interim order is not valid according to law.
Responding to the statement of the Prime Minister, the Bar Association of Sri Lanka noted that the decisions of the Constitutional Council are clearly amenable to the fundamental rights jurisdiction of the Supreme Court as per Article 41J of the Constitution. In a statement, the BASL added that it is equally clear that following the 19th Amendment to the Constitution, the exercise of powers by the President, except his power to declare war and peace, are subject to the fundamental rights jurisdiction of the Supreme Court as per Article 35 of the Constitution. The association further claimed that in the said cases, a 3-judge bench of the Supreme Court heard all parties, including the Attorney General and the Counsel for IGP Tennakon, and delivered its order granting leave to proceed, adding that the court also issued an interim order restraining Tennakon from exercising the duties, functions and powers of the Inspector General of Police until the final determination of the applications. The BASL added that the said cases had been fixed for hearing on the 11th of November 2024 with the consent of all parties including the Attorney General and all counsel. Reaffirming the judiciary's independence, the BASL stressed that the Supreme Court's decisions cannot be overruled by any other body, including the Prime Minister or the Speaker of the House. The association warned that any failure by the government to respect court decisions would erode public confidence in the justice and jeopardize democracy.